is now in session. Please be seated.
Okay. Is appellant here?
He was here before the break and he stepped out.
Ah,
I asked the trooper to go get him.
Okay.
He didn't see him.
I believe he's coming. All right, sir. If you'll come up to the podium, please.
State my name.
Oh, hold on just a second. I want to make sure we're all on the same page
Yes,
before
sir.
we start. You're Mr., is it Fischiettie?
Fischiettie.
Okay. I know you've sat through one of the hearings this morning. Do you understand the process that we're following here?
Yes, sir.
Okay. When we start, what I will need for you to do is say your name, and that when you do, those lights will come up. And you'll have a green light, yellow light, and red light. And you heard what I said about that earlier. So,
Yes, sir, I did.
okay. First thing I need to know is, do you want any rebuttal time? In other words, do you want to use all your time in your main argument, or would you like to come back and have some period of rebuttal time?
I would like to reserve 5 minutes for rebuttal.
Okay, all right. You've seen this process. I hope you understand it. Do you have any questions about it before we get started?
Not at this time.
Okay, all right then. When we start, you can just tell us whatever you want to tell us about your case. You'll do that for 10 minutes. The opposing counsel will come up, make his argument, and then you'll come back and have 5 minutes for your argument.
Yes,
okay?
sir. Yes, sir.
All right, we ready, Miss Angie?
Jontae Fischiettie versus Econo Auto Painting of West Tennessee.
All right, sir. And now if you'll just tell us who you are, and then we'll start.
Jontae Fischiettie, not a lawyer. In this matter, this is a case about a breach of contract. It's not a personal injury. It's not a personal property claim. It's a breach of contract. The main points of my appeal is the abuse of discretion. All issues were reserved for jury trial. The court entered an order of a confession of judgment and dismissed it. In order for you to have a valid confession of judgment, there are certain elements that you must have. You must have an agreement among the parties of the damages. You also must have a declaration from the lawyer as well as the defendants. We don't have that in this case. The only party that agreed to the amount of damages is the opposing counsel, Mr. Glassman. The punitive damages claims were properly reserved for jury. That was also dismissed by the court. There's another issue that I was addressing earlier. In the appellate's brief, he raised Rule 27 and Rule 6. I did review the rules of the appellate court. I used what was available to me to write my brief, which was the docket entry sheets. I didn't have access to all the dockets that they forward to the court. I used the docket sheets. I did properly raised my points of review. I also used the docket sheets to point to the cases or the sections that was prejudice in the court. I would like to circle back to the confession of judgment. There's nothing in the record. There's no signed or verified statement from the defendants. There's nothing in the record from the attorney. There's no attorney's declaration. And before I even perfected this appeal, I looked at LexisNexis. I looked at everything that was available to me, and I couldn't find not one case where the state of Tennessee supports a confession of judgment in a breach of contract case. I couldn't find not one case law to support the judgment. That's it.
Okay. All right, sir.
Thank you.
Thank you.
I'm Richard Glassman of the Nashville Bar and the Shelby County Bar. I'm tempted to say I have nothing to say. This has been typical of Mr. Fischiettie. He has filed 16 different lawsuits against lawyers, judges, clerks. He currently owes my firm $25,000 plus for a judgment that was entered in federal court against him for wrongfully suing me personally and my firm. He threatened previously the prior law firm defending this case with suing them and reporting them to the board, and they withdrew, and I took the case over after having been warned by them that he would do the same thing, and he did. He is very familiar with the rules of court because he's been here a whole bunch. He has not cited to one single part of the record, not once. There were court reporters at every single hearing. He has not used any of those transcripts. He has not referenced any record. This court is not required to dig through this record and find what he says occurred where, what, and when. And he knows it. He's an experienced litigator. I do want to give credit to Jim Horner for our submission because Jim Horner wrote it. I'm here to sustain it. Mr. Fischiettie has had a problem with the word confess, judgment. It's the same as conceded. We conceded judgment. There was nothing left. After we got partial summary judgment on every single allegation of his complaint, there was nothing left but the amount. He had submitted, a repair bill for his vehicle. We paid that repair bill. In his deposition, he said he had no other evidence, which is part of the record. He had no other evidence of quote-unquote damages. We paid it. It's sitting in circuit court over $6,000. We conceded to judgment. There was nothing left to litigate. The court had ruled upon every single aspect of his case.
Did he try to renew? I know he dismissed some claims and then moved to renew some claims, another claim rather. Did the trial court rule on that?
The loss of use claim. That claim is controlled by the Yazoo case that we cited in our brief, which clearly says if he doesn't make an attempt to have his vehicle repaired, you can't wait 5 years and say, okay, now I want to have it repaired and I want 5 years loss of use. The Yazoo case is smack on point, and he doesn't want to recognize that. And
Did the trial court allow that claim?
No.
Did the trial court ever even rule on that claim?
At the time the trial court made its ruling, he had withdrawn that claim. And then he attempted to make give notice that he was now claiming it again, but he filed no motion to amend. He filed no motion to reinstate the loss of use. He just gave notice, as he calls it. In other words, stand on top of a building and holler, "I now claim loss of use." There's no motion. There's no amending his complaint. There's no substitution of anything. It's just notice. And he considers notice to be something we have to act upon. He has violated Rule 27 and Rule 6 at every step of the way. In this case, he is not a true pro se litigant. He is very experienced at litigating in these courts and federal court. In our brief to your honors at page 30, at the footnote at the bottom of the page, we list the 17 cases that he either has pending or has previously filed. In more than 6 of those cases, damages in the form of attorney's fees have been assessed against him. He took great issue initially with an order that was entered regarding meaningful mediation. We attempted to get Justice Holder to mediate this case. She ultimately withdrew because this gentleman threatened to sue Justice Holder. We then got former Sixth Circuit Court of Appeals judge to try and mediate this case. She too withdrew because he threatened her. We could not, then we moved for judicial mediation, and no judge would take it because of this gentleman's reputation. The mediation never occurred. We finally said, let's try a different way, and that was to resolve all of his allegations and then move forward. As to the loss of use, the case law that is clear allows him reasonable loss of use under certain circumstances. But in this case, he has never gotten the vehicle repaired. It's almost a comedy of errors as to how this occurred, but he has never taken steps to get the vehicle repaired. And in his deposition, I asked him why, and he said because his roommate told him to not get it repaired. So he's just sat there for years without getting the vehicle repaired. The vehicle is operable. It's I'll call it an elderly Kia with, I believe, over 300,000 miles. And my client painted it the first time the wrong color and painted it the second time it had splotches, and he deemed it to be unusable. Mechanically, there's nothing wrong with it. My client did nothing to the operation of the vehicle. It's only painted is all my client did to it. And he claims that he cannot get it repaired, although he has submitted from Mako, as I said, the statement for over $6,000, and that's the amount that we paid into court, the exact amount that he claimed would take to put the vehicle back into its prior condition. The vehicle has been operable for every second since the vehicle was painted. It's just the appearance of the vehicle. Unless you have any questions, I have nothing else to say.
See none. Thank you. Sir?
First, I would like to address all the court cases that Mr. Glassman is not correct. 7 of those cases that he named, we settled. The car in question that he's talking about as an elderly Kia is parked outside. It is a 2012. We bought it when it had 21,000 miles on it. I now have over 300,000 miles on my car. I love my car. He is not correct. From the time that this happened, we submitted 8 settlement offers to them. From the minute that he called, we discovered it was painted the wrong color the first time. The car has been painted the wrong color 3 times. It's white. It's silver. It's dark gray. It's green. It's ugly. Like I said, it's parked outside. Not only did we submit the 8 settlement offers, that car has been returned back to them 4 times. All 4 times we were asked to leave the property. The last time we took it to them to correct was up on Pleasant View in Memphis, Tennessee. Mr. Farmer himself threatened to call the police on us, so we left his property. The loss of usage was never addressed by the court. I submitted the notice of renewal way before the judge even entered the judgment. It was never addressed by the lower courts. When we went to address the confession of judgment, he's saying that it's the same thing as saying conceded judgment. It is not. When you concede to a judgment, you basically is agreeing with it. When you do a confession of judgment, there's certain requirements you must have under Tennessee law. You must have a declaration from the attorney. You must have a written agreement from the parties agreeing to the damages. We've never agreed to the damages. Thank you.
Thank you. Thank you, folks. We will take this matter under advisement and we'll render an opinion as quickly as we can.
Thank you.
Thank you. You may be dismissed. Ms. Angie, you may call the next case, please.
In Ragnet